Good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, and so I do encourage you to speak with your attorneys before speaking on the record today, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me and are able to address your cases from here. If I call your name and your attorney is not in the room at that time, you can let me know that and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have attorneys present from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these representatives are present this morning to help facilitate the court session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at First Appearances if you are here on misdemeanors or municipal ordinance matters, but understand that that is dependent on what is going on with you personally and with your case. For those of you here on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at First Appearances. After today, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. Before we get started today, I know we have a few individuals that have private counsel and family members signed in. But let me first ask, Mr. Miller, has the jail requested that anyone be called out of turn this morning?
Yes, Your Honor. First, we do have the Spanish interpreter present.
I do see. Do we know which cases?
On page 10, Concepcion. Okay. And page 12, Baez.
All right. And who do I have from the jail that's going to need to be called out of turn?
There's two individuals, Judge.
Okay.
First one is on page 9, and that would be Mr. Washington. The second gentleman is on page 16, and his name is Mr. Daniel Garcia.
Okay. All right, let me pull those out and then we'll get started. Yeah, Washington on page 9.
Okay.
I'll start with Washington and Garcia, and then we'll do the two Spanish interpreter cases. And then I'll go to our sign-ins. All right, Mr. Marvin Washington. Thank you.
How you doing?
Good morning, Mr. Washington. You're before the court this morning on one charge of felony battery. I find probable cause, and I'll hear from the parties.
State would be requesting a $3,500 bond, no victim contact. His prior conviction, 2014, for an aggravated assault with a firearm and battery. He was sentenced to just under 38 months in Florida State Prison. 2012, dealing in stolen property, false ownership info on a pawn item, VOP. He received the same prison sentence. Resisting without violence, 2011. He has additional priors, but those are the most relevant, Judge.
See when he was released based on that sentence?
I can get that information one moment, Judge. Nancy, do you have any notes? Washington. I can, Your Honor, I can get that information. I just need
So while you're doing that, Mr. Romero, do you want to go ahead and go?
Yes, Judge, as you heard, he does have a prior record. However, since he's released from incarceration, I believe it was January 2018, he's been clean, Judge. He's 30 years old, been here his whole entire life. Right now, he's working. He's been working for the same company since he got out of jail, at KFC, making about $9.75. Now, I see here this is not in custody capias. I believe this allegedly happened last year, and he has had no contact with that victim in a year. Now, he lives locally here in Fort Lauderdale with him and his girlfriend. They rent an apartment. They've been renting the same apartment now for about a year and a half. I believe their monthly rent is approximately $800. Now, he did give me the phone number of his girlfriend. I'm going to be contacting her after court to help post a monetary bond. My understanding, though, is she's a hairstylist, and from what Mr. Washington advised me, their financial resources are quite limited. I was going to be asking for about a $1,500 bond on Mr. Washington's behalf, Judge.
showing I am showing he was released in January of 2018. Nothing further.
All right, the bond's going to be set at $2,500. There will be an order of no victim contact. Based on what Mr. Romero has advised, that should not be a problem. But Mr. Washington, just so that you understand my no contact order, that means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, and no social media. Do you understand that, sir? Thank you.
Good luck, Judge.
All right, now I'll take Daniel Garcia.
Judge, I do have an argument as to counts 1 and 2.
Okay, good morning, Mr. Garcia. You're before the court this morning on 3 charges. Count 1 is for battery on an officer, firefighter, or EMT. 2 is for resisting an officer, obstructing with violence. 3 is for loitering or prowling. And Mr. Miller, I'll hear your argument at this time.
Judge, it doesn't appear that Mr. Garcia participated in any violence, although it seems like some has been visited upon him. The probable cause says he attempted to pull the officer's arms off. He pulled away from the officers, but nothing violent from him, certainly nothing to warrant this sort of beatdown. Judge, I would argue that there's probable cause for resisting without violence, no probable cause for battery on a law enforcement officer.
Well, Your Honor, I would direct the court's attention, I guess Mr. Miller's, to the last sentence of the second page, where it alleges that Garcia then attempted to take Officer Rodriguez's taser away from her. Certainly that is offering violence. Then, the next page, Garcia continued to fight and grabbed Officer Rodriguez's arm in a forceful manner and began to squeeze. That is battery on a law enforcement officer.
Or it could be self-defense.
That's an affirmative defense. That doesn't defeat probable cause at this point in time.
Okay, for the purposes of today's hearing, I'm going to make a probable cause finding with respect to the 3 charges, and I will hear the party's recommendations at this time.
Judge, to speak Mr. Garcia, he's been living here almost half of his life. He's 36 years old, but unfortunately he's financially indigent. He's homeless, he owns no property, has no money in bank, no one's going to help post a monetary be He's asking to be released on pretrial, but more importantly, we're going to be requesting a photo order so we can photograph the injuries that Mr. Garcia sustained.
My concern is, Your Honor, is that Mr. Garcia is currently out on release right now before Judge Porth for resisting with violence and disorderly conduct. I'm going to be requesting a $2,500 bond on count 1, $1,000 bond on 2. Actually, Your Honor, can I have 1 moment? Correction, he is out on 2 separate cases of resisting with violence against law enforcement.
Are those both in Judge Porth's division?
They are.
All right, at this time, bond on count one will be set at $2,500. Bond on count two will be set at $1,000. I'll leave the standard bond in place on count three. And I will sign the photo order that was requested. And I'll go to our two interpreter cases now. First will be Yariel Concepcion Rivera, and for my interpreter,
Señor
please raise your right
Concepcion.
hand. Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do. Esteban Rojas.
Thank you, Mr. Rojas.
Concepcion.
Good morning, Mr. Concepcion.
Buenos días, señor Concepción.
You're before the court this morning on 5 charges.
Usted está ante este tribunal hoy con 5 cargos.
Count 1 is for failure to register a motor
El
vehicle.
primer cargo es no matricular un vehículo automotor.
Count 2 is for having an expired temporary tag.
El segundo es por tener una placa provisional vencida.
That count is not for magistrate.
Ese cargo no es para este tribunal.
Count 3 is for driving while license suspended,
El
first offense.
Tercer cargo es conducir con la licencia suspendida en calidad de primera infracción.
Counts 4 and 5 are out of county holds.
Los cargos 4 y 5 son órdenes de captura desde fuera del condado,
Those are both from Collier County.
del condado de Collier.
I find probable cause,
Considero que existen indicios probables.
and I'll hear from the parties if they wish to be heard.
Escucharé a las partes si tienen algo que decir.
Judge, Mr. Concepcion is requesting an ROR on the Broward, count 3 on the Broward offense.
Su señoría, el señor Concepción está solicitando libertad bajo palabra por el tercer cargo, el de Broward.
Your Honor, state would object. It's the same offense that he's wanted out of Collier County for.
Su señoría, la fiscalía objeta es la misma infracción por la que es buscado en el condado de Collier.
He's failed to appear, obviously, out of Collier County.
Obviamente que ha incumplido con su obligación de comparecer ante el tribunal en Collier.
He also has a $10,000 bond out of Dade County for failing to appear in a traffic matter.
Y también en el condado de Dade tiene una fianza de $10,000 pendientes por no comparecer en un tema de tránsito allá.
I see no reason why Collier County's same level offense should take priority over Broward's.
No veo por qué la infracción, que es la misma en el condado de Collier, tenga que tomar precedencia sobre la misma infracción en Broward.
All right, in light of that information, I'll leave the standard bond in place on count 3.
Con base en ello, voy a dejar la fianza de rigor tal cual en el tercer cargo.
Thank you.
Gracias.
Next will be Jose Baez.
He's approaching, Judge.
Thank you. Good morning, Mr. Baez.
Buenos días, señor Baez.
You're before the court on 2 charges.
Usted se encuentra ante este tribunal con 2 cargos pendientes.
Count 1 is for DUI, alcohol, or drugs,
Primer
first offense.
cargo es DUI por alcohol o drogas, la primera infracción.
2 is for DUI with a blood alcohol level greater than 0.15.
El segundo cargo es por un DUI con un nivel de alcohol en la sangre mayor a .05.
I find probable cause,
Considero que existen indicios probables
and I will hear from the parties.
y ahora escucho a las partes.
Judge, my understanding, Mr. Baez has no prior record. He's been living here for 25 years.
Su señoría, tengo entendido que el señor Baez no tiene antecedentes, ha estado viviendo acá durante 25 años.
Based on that, I'm going to make 2 requests. One, if the court would consider on count 1 alone an ROR.
Con base en ello voy a hacer 2 solicitudes. Primero que nada, si su señoría tomaría en cuenta la posibilidad de darle un libertad condicional para el primer cargo
And a phone order, so he can call someone and post his bond on count number 2.
y una orden para darle acceso a su teléfono para que pueda pagar la fianza para el segundo cargo.
No objection.
La fiscalía no tiene objeción.
All right, in light of that, count 1 will be an ROR.
Bien, dado lo anterior, entonces para el primer cargo, libertad condicional.
Count 2, the bond will remain at
Para el
$1,000.
segundo cargo, fianza de $1,000.
And I will sign the phone order that was
Y voy a
requested.
firmar la orden permitiéndole acceso a su teléfono.
Thank you.
Gracias.
Is there anyone else at the main jail that needs a Spanish interpreter?
No one else here at main, Judge.
Okay. Is there anyone at Paul Ryan, Conti, or North Broward that requires a Spanish interpreter?
No, Your Honor, and full line.
Okay. All right. Thank you, Mr. Rojas.
Sure.
Okay, I'm going to go to a couple of our cases that have sign-ins, if they're present at the jail. On page 4, Brianna Hughes, her private counsel is present in the courtroom. Good
Please come
morning.
on up. There's your private attorney, okay?
Before you, I'm Richard Bellis, pleasure.
Nice to
First
see
time
you, Mr.
appearing before you.
Bellis.
Good day.
Good day. Okay, good morning, Ms. Hughes. Ms. Hughes, you're before the court this morning on 2 charges. Count 1 is for burglary of an unoccupied dwelling unarmed. 2 is for touch or strike battery. I find probable cause. I do have your attorney, Mr. Bellis, in the courtroom with me, as you heard, Ms. Hughes, and at this time I'll hear from the parties.
Your Honor, I believe we have an agreed, we have an agreement, if it's acceptable to the court,
Okay?
be a $6,500 bond on count 1, $1,000 bond on count 2, no victim contact with either Shalakash Joseph or Jean Joseph, and no return to the listed residence.
Mr. Bellis?
Yes, Judge, if I could just introduce myself to this young lady. I know her employer for a couple of years, Joe at Tin Fish. I've done work for some of your fellow employees. He wanted me here today. I believe this stipulation is in your best interest. It's essentially a $7,500 bond, which Joe said that he would speak to your family and people, and you would likely be able to post. Is that acceptable, ma'am?
Ms. Hughes, that Mr. Bellis is speaking to you. Here, press the button on the mic. Press the button on the mic so I can hear you.
I can't hear you guys.
Okay.
I ain't hear nothing he just said.
Okay, my name's Richard Bellis, young lady.
Can you
Joe,
hear that?
your employer. Can you hear me now?
Yeah.
Okay, your employer, Joe at Tin Fish, who I know very well, and I've done some work for your co-workers. He wanted me to be here. I had agreed, subject to your approval, to basically a $7,500 bond and no contact with the alleged victims. And Joe indicated he would speak to your family, and you would likely be able to post that bond. I would suggest you agree to that stipulation. If not, I could ask the judge to do better, but in my opinion, I don't believe that's an unreasonable bond.
I'm gonna just go with that.
All right, Ms. Hughes. Okay, I will approve the agreement of the parties. The bond on count 1 will be set at $6,500. The standard bond of $1,000 will remain on count 2. And Ms. Hughes, as discussed, there will be a no victim contact order as well as a no return order. That means that you're not to return to the residence that this allegedly occurred at, and you are not to have any contact with either of the alleged victims. That means no being in the same place at the same time. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that?
Yes, ma'am.
All right, thank you very much. Good luck,
Thank you,
Ms.
Judge.
Hughes. Thank you, Mr.
Don't
Bellis.
discuss your case with anybody over the phone, ma'am, and give me a shout when you get out. Thank you.
All right, thank you, Mr. Bellis. All right, next, if he is present at the jail, Mr. Alan Carvajal on page 21. His private counsel is present in the courtroom.
Good morning, Your Honor. Eric Matheny on behalf of Mr. Carvajal.
Good morning,
Alan,
Mr.
how are
Matheny.
you? My name's Eric. Your family is here. I got your wife here. I got your sister here and your brother-in-law are all here. They called me and asked me to be here for you. Your Honor, I had an opportunity to speak to Mr. Linder this morning. We reviewed the probable cause. For purposes of the bond hearing,
Yes.
we would stipulate to probable cause, and we've agreed to a $5,000 monetary bond with no victim contact, that being the only condition. So just be a $5,000 bond. Your family's indicated that that's okay. We're going to post that bond and just have no contact with the victim. Would that be okay with you for bond purposes?
Mr. Carvajal, can you hear what your attorney is saying?
Is that okay?
Yes.
Okay.
All right,
we're gonna
Mr.
go with that.
Linder? Anything else? All right, then, for record purposes, I will make a probable cause finding. The bond will be set at $5,000. There will be an order of no victim contact. Mr. Carvajal, so that you understand my no contact order, that means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, sir?
Yes.
All right, thank you very much.
Okay, we're going to get that posted now. Thank you, Your Honor.
Thank you, Mr. Matheny. if there's no one else that needs to be called out of turn, until Mr. Shake comes back for the MOs, I'll go ahead and go through our regular list here. First up will be Samantha Payne.
She's here, main judge.
Thank you. Good morning, Ms. Payne.
Good morning.
Ms. Payne, you're before the court this morning on 3 charges. Count 1 is for aggravated assault with a deadly weapon, domestic violence. 2, touch or strike battery. 3 is for child abuse without great bodily harm. I find probable cause for these charges, and I will hear from the parties at this time.
Your Honor, I see no history. That being said, I'd be requesting a $5,000 bond on count 1 based on the allegations, and this, I believe, was caught on, was video recorded, threatening to kill the victim, following him with a knife while he was carrying their child. Like I said, making a threat what she would do if she had a gun. And I'd be requesting a $2,000 bond on count 3 based on the level of violence. Nothing further.
Mr. Romero?
Judge, as you heard, Ms. Payne has no prior contact with the criminal justice system. She's a registered voter here in our community. She's been here her whole entire life. She's 36. Right now she is employed. She does medical coding. She's been doing that since 2005. My understanding is, and Ms. Payne's understanding is, I believe the alleged victim has moved out. So she's going to be returning where they were living. But I did advise her if he's not there, there is a no contact order in place, and she will be abiding by that no contact order. I'm going to be requesting, based on the fact, Judge, that she has no prior contact with the system and her very strong ties to the community, I'm going to be requesting a $3,000 bond on count 1, leave the bond in place on count 2, and I'm going to be requesting a $1,000 bond on count 3. So the total the defense is requesting for, I believe, if my math is correct, is about a $5,000 bond, and we're going to be asking for the court to sign a phone order as well.
All right. The bond on count 1 will be set at $3,000. The bond on count 3 will be set at $1,000. Standard bond will remain on count 2. There will be an order of no victim contact. That will relate to both of the alleged victims in this case. I'll sign the phone order that was requested, Ms. Payne, so that you understand my no contact order. That means no being in the same place at the same time as either of the alleged victims. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, ma'am?
Yes.
Thank you. Raisha McQueen.
Come on up, man. She's approaching Judge at Maine.
Thank you. Good morning, Ms. McQueen.
Good morning, Judge.
Ms. McQueen, you're before the court this morning on 1 charge of aggravated assault with a deadly weapon, domestic violence. I find probable cause, and I'll hear from the parties.
Your Honor, Ms. McQueen has no history. I'm going to be requesting a $10,000 bond, no victim contact. My concern is not only for the safety of the victim, but based on this allegation and considering that there were witnesses to the act, just the mere fact that she brought a firearm to Extreme Action Park on a Sunday, looks like at least during the afternoon to early evening, and was threatening the victim, she put additional people, patrons' safety at risk as well.
Thank you. Mr. Romero?
Judge, as you heard, she has no prior contact. I understand the allegations are serious. However, there is a backstory to this, Judge. And I'm sure they're going to go ahead and get into that once she did apply with the public defender, once the public defender speaks to the case filer. But my understanding, Judge, she was residing in New York. She's relocated from New York to Florida to escape the alleged victim. She's been residing here now for about 2 years. The reason why she escaped, Judge, she was in great fear. Having said that, Judge, now she's started her life down here in South Florida. She works at Comcast and customer service, Judge. She does have family here that can help her while she goes through this, specifically her aunt. But her aunt, Judge, is the person that's going to be financially posts her bond. Her aunt is retired, and she is on a fixed income, and there's no way she's gonna be able to afford to post the bond which the state has recommended. We're gonna be asking if the court would consider a $3,500 bond on Ms. McQueen's behalf.
Mr. Linder, you said she has no priors.
None that I see, Judge.
All right, I'll set the bond at $3,500. There will be an order of no victim contact. Ms. McQueen, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, ma'am?
Yes, Judge.
Thank you. Tiffany Sowers.
No prior, Your Honor. She's medical reset.
Okay, thank you. Jemiah Broomfield.
Paul Ryan, I believe, Judge.
Thank you.
Paul Ryan.
Thank you. Good morning, Ms. Broomfield.
Good morning.
Ms. Broomfield, you are before the court this morning on one charge of aggravated battery with a deadly weapon. I find probable cause for this charge, and I'll hear from the parties at this time.
Your Honor, based on the allegations, I don't know if she has a history or not, but other than traffic-related matters, I would be seeking a $15,000 bond, no victim contact.
Mr. Miller?
Your Honor, Ms. Broomfield is a lifetime resident of South Florida. She's lived at the same house for her entire life. She's a graduate of Blanche Ely High School. She's currently registered at Florida Career College. She's studying medical assistance. She does have a 4-year-old son who is currently with the mother, or she's in school, but the mother will be taking care of her. As such, she's not currently employed. $15,000 bond is going to be out of her reach. This charge, Your Honor, allegedly, it is a filed charge from September of last year. And as Mr. Linder pointed out, she has no priors. I think she's a good candidate for pretrial supervision.
She's not
And so we
legally
would be
entitled.
requesting that.
Under Florida statute, she's not legally entitled to release the pretrial based on the nature of this offense.
I understand the word entitled, does that mean she's not eligible for pretrial supervision?
Florida statute specifically states anyone charged with a dangerous crime is not eligible for release outright ROR to pretrial, any pretrial supervision program at first appearance.
Judge, we would ask for $1,000 bond and pretrial supervision.
I'll set her bond, her monetary bond at $3,500, and if she does post that, then she will be placed on pretrial supervision. There will also be a no victim contact order, Ms. Broomfield, so that you understand that order. It means no being in the same place at the same time as the alleged victim. It also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that?
Yes, ma'am.
Thank you.
Judge, Paul Ryan has asked if we could handle Anderson, who's on the last page of the docket. That is their only other defendant this morning.
Okay.
And it's a perfection from, I think, Sunday
From the
or
weekend?
Saturday.
Yep. Okay. All right, good morning, Miss Anderson.
Morning, ma'am.
All right, this is a perfection of count 3, which is a charge for aggravated battery.
I don't have anything additional, Your Honor.
Nothing additional?
No.
All right, then on count 3, I will maintain Judge Murphy's finding of no probable cause, which means that on count 3, she's eligible for an ROR, which I believe is already reflected on the finding sheet, and Judge Murphy's other rulings with regard to his bond amounts on the other counts will remain in place.
Thank you, Your Honor.
Thank you. Thank you, Ms. Anderson.
Thank you, Your Honor.
Yeah, this was just a perfection for count 3. Everything else will remain as Judge Murphy said it. All right. On page 4, Vanessa Rodriguez, her private counsel, is present in the courtroom. Good morning.
Just reviewing the probable cause affidavit.
All right. Good morning, Ms. Rodriguez. Ms. Rodriguez, you're before the court this morning on 3 charges. Count 1 is attempted felony murder. 2 is child abuse without great bodily harm. 3 is criminal mischief between $200 and $1,000. Your private counsel is present in the courtroom with me, as I have stated. And I'll hear from the parties at this time.
Your Honor, the state would be seeking a finding of proof evident or presumption great for attempted murder on count 1. Clearly, the evidence would indicate that this was an intentional act, considering that Ms. Rodriguez essentially stalked the victim while driving her vehicle while he was on his bicycle. That she actually drove into oncoming traffic to get towards him, ended up driving on the grass, Your Honors, and ultimately striking him on his bicycle, causing the bicycle to get crushed under the car, flipping the victim on top of the hood of her car, crashing into the windshield. There's physical evidence that the windshield was completely shattered. One moment, Your Honor. Considering Ms. Rodriguez's actions after the accident, yelling and cursing at him, it does not appear from her response that this was an accidental crash. For some reason, when a bystander handed her accidentally his phone, she decided to smash his phone on the ground. There's no evidence here, Your Honor, to indicate that this was anything but an intentional act. And certainly it was an act that could cause the death of the victim.
Your Honor, respectfully, I don't know where we're getting stalking from. The state starts off with the defendant is stalking the victim. There's nothing here that says anything about that in the probable cause affidavit other than she's driving down the street or the alleged victim is driving down the street and sees a car coming in that direction. It's speculative of the state at best to say that this is more than a car accident and to take the actions of the alleged victim after the incident of throwing a phone on the ground. I don't think we can put rhyme or reason to what somebody does after they're in a car accident, especially when they realize potentially that they know the person that they may have just accidentally hit.
Your Honor, and clearly, and I think the court realizes, and I'm sure Mr. Martin realizes, I wasn't using the term stalking as that she committed a criminal offense of stalking. I was using it to describe her actions, her driving pattern, which I think is a fair description based on the allegations.
Anything further, counsel?
No, I would go over, that stalking is an exaggerated term that deals with somebody going after somebody, looking for somebody, following somebody, knowing their patterns, and somebody with their child in their car, and then a person riding on a bicycle doesn't equate stalking. But it seems there is a serious car accident. The defendant did not leave the scene of the accident. And it's, from my 25 years' experience, somebody who's looking to do an attempted homicide, one, would not have their child in the car, and two, would leave the scene of that accident. So it may be that the state is actually overcharging the defendant in this matter.
First off, state hasn't charged anyone. A law enforcement officer arrested her for a charge. And also, I believe, one moment, Your Honor, the vehicle was unable to be driven any further because the victim's bicycle was stuck under it.
Bicycle under a car and a smashed windshield doesn't stop somebody from driving away. I think everyone in this room knows that.
I think that you're both getting off track. From what I'm seeing in this probable cause affidavit, it alleges that she swerved into oncoming traffic and continued into the grass, allegedly in order to intentionally strike the victim in this case.
That's
The
all.
officer does indicate in the probable cause affidavit that the vehicle was unable to be driven any further due to the windshield damage.
Your Honor, respectfully, windshield damage doesn't stop a vehicle from being driven. It stops it from. it
Counsel, I'm
should
just
be
stating
driven,
what's
but-
in the probable cause
Yes, Your Honor.
affidavit. Thank you.
And I'm reflecting that it's an exaggeration by law enforcement that a broken windshield does not stop a vehicle from driving.
Well, I do take note that the probable cause affidavit also includes information pertaining to the texting conversation that occurred shortly before this happened between the defendant and the alleged victim. Obviously, he's known to her since they were in a relationship. This is happening after midnight with the defendant and her 15-year-old daughter present in the vehicle in the front passenger seat. All right, for the purposes of today's hearing, I'm gonna make a probable cause finding with respect to these three charges. As to count one, I will make a preliminary finding of proof evident presumption great in order that Ms. Rodriguez be held no bond on that count. That is without prejudice for her to have the appropriate Arthur hearing before her division judge. Now, I do need to hear the parties' recommendations as to count two, so I'll hear those at this time.
Your Honor, I'd request a $2,500 bond on count two.
Any objection to that, counsel?
And how much was that?
2,500 on.
No objection to that, although the defense doesn't see the child abuse other than her being in the vehicle. Your Honor, would the court consider granting a bond on count one?
Are you gonna give me some more information on your client?
I can. She's a long-term resident of Broward County. It states her permanent address as 4111 Southwest 25th Street in Fort Lauderdale. She clearly is a mother with children. And I don't believe she has any priors.
Well, first off, that she has a child, I think is really not as great a mitigating factor considering her child's presence in her car didn't stop her from committing these alleged acts. And that's where the child abuse comes from. Additionally, Your Honor, she's got some dated priors, possession of cannabis with intent to sell 2002, resisting without violence 2000. But Your Honor, based on the nature of these allegations, I would ask that the court keep Ms. Rodriguez held no bond. I think an Arthur hearing would be appropriate in this situation, considering the level of violence, considering the extent that Ms. Rodriguez went to commit this act. I do have concern for the victim's safety going forward.
Your Honor, the defense stated the child as ties to the community, and her requirement to be in the community, not as a mitigating factor. And taking a look at the probable cause affidavit, I believe the officer said he may have broken a bone. I don't even see any injury to the alleged victim on this. Transported to Broward Medical Center, stable condition, possibly sustained a broken or fractured bone. Doesn't even say that the defendant suffered any permanent or substantial injury in this alleged attempted homicide. I'd ask the court to grant a $10,000 bond on count one.
All right, I'm gonna deny the request at this time. I'll leave the no bond hold in place, and it can be taken before the division judge later this week to address that issue. Thank you, gentlemen.
Thank you, Your Honor.
Next will be Caridad Leon, or Leon.
Come on up. She's approaching Judge here, ma'am.
Thank you. Good morning, Miss Leon.
Good morning.
Miss Leon, you're before the court this morning on one charge of aggravated battery on a person 65 years of age or older. I find probable cause, and I'll hear from the parties.
Judge, Miss Leon is not going to be able to afford any sort of financial bond. From what she advises me, she is homeless. She gets disability, but her payee, I believe, is her grandmother. Miss Leon, like I said before, she has no money in the bank. She owns no sort of property. So there's nothing she can afford. So I'm asking you, the court, to keep that in mind, in the court's mind, in determining reasonable release conditions. And I also ask for a photo order as well.
I'll sign the photo order.
Your Honor, I have some concerns considering Ms. Leone was arrested in November of last year for committing a battery against her grandmother. It was dropped. Ms. Leone, her grandmother, did not want to prosecute. In 2017, she was arrested for, again, battery on a victim over the age of 65. That was involved the same victim as in this case. And that was dismissed based on competency grounds. She had a battery on a law enforcement officer dismissed on competency grounds, a domestic violence battery in violation of a pretrial release condition dismissed on competency grounds, a misdemeanor battery in 2015 dismissed on incompetency grounds, and 2014 an aggravated assault also dismissed on incompetency grounds. Obviously, there are other issues going on here that I think need to be dealt with, but my concern until she can get in front of a assigned judge with better information than we have today, I think there is a safety concern. So I'm going to be requesting a $5,000 bond and no victim contact.
Based on what I'm hearing, it does seem that there may be some underlying issues that need to be addressed with her division judge and potentially with Judge Porth and his division, maybe at a later date. For today's purposes, I will grant the state's request and set the bond at $5,000. There will be an order of no victim contact. Miss Leon, so that you understand my no contact order, that means no being in the same place at the same time as the alleged victim. It also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, ma'am?
Yes.
All right, thank you very much. Latanya Pink.
I believe North Broward.
Hi, hello.
All right, good morning, Ms. Pink. You're
Good
before
morning.
the court this morning on two charges. Count one is for aggravated battery causing bodily harm or disability, or disfigurement. Two is for burglary with assault or battery. I find probable cause, and I'll hear from the parties at this time.
Your Honor, I'm going to be requesting a finding of proof evident or presumption grade at this time for first appearance purposes, and that Ms. Pink be held no bond on count two. Now, obviously, I understand this involves her unlawfully going into the victim's car. The reason I'm seeking no bond, and my greatest concern, is that she did this while in possession of a knife and attacked the victim with the knife, striking him in the forehead. I would note according to this, there's an independent witness that provided a sworn statement. So
I could talk.
Not right now, Ms. Pink, one moment.
Oh, okay.
So this does rise above a mere he said, she said. The victim did suffer a small laceration to the right side of his forehead. I'm also concerned because there does not appear to be any reason or provocation for this act.
All right, Mr.
And,
Miller?
and Judge, that's kind of the problem with finding proof evident presumption great based solely on the hearsay testimony of a document. We don't know what happened here, and there's a lot of questions that aren't being answered. And so I would object to the court finding proof evident presumption great solely on the probable cause affidavit.
And again, the court, I know the court is familiar with Bracken v. Saza. Mr. Miller's objection is not a legal objection pursuant to holdings by the 4th DCA. She had a battery, domestic violence in 2013 that was dropped. That's all I see, Your Honor.
All right, I do see per the probable cause affidavit that there were allegedly witnesses, or at least one witness besides the victim to the incident, but none of the information regarding the witness statement has been provided to me in the probable cause affidavit. The only information that I'm seeing is the statements that were provided by the victim. Based on that, for today's hearing purposes, I am not going to make a preliminary finding of proof evident presumption great. And at this time, I'll hear the parties' recommendations as to bond for both counts 1 and 2.
Your Honor, I would be requesting a $10,000 bond on count 1, $20,000 bond on count 2, pretrial release with a GPS monitor. Obviously, this would be subject to potential further modification, but at this point in time, considering the allegation of an unprovoked attack with a knife, unlawfully entering the victim's vehicle, I think these bonds and conditions would be appropriate.
Okay.
Can I say something?
Ms. Pink,
Pink,
one moment.
don't-
Let me hear from your attorney, Mr. Miller, who's present in the courtroom with me. Go
Ms.
ahead,
Pink,
Mr. Miller.
I'm going to ask you, before you speak, if you indeed decide to speak, not to talk about anything that happened. Okay, everything you're saying is being recorded, and if you say anything that can be deemed an admission, it will be used against you later. So I'm going to ask you not to talk about anything to do with the facts of your case. If you need to add, as far as your ties to the community, I'm happy for you to do that. That being said, Your Honor, she's been living in South Florida for more than 20 years at the same address for more than 10. She is a licensed, de-licensed security guard, licensed by the state of Florida. However, she is seeking to improve her condition, and she starts medical assistant training at Concord University Institute. She does have family in South Florida, including a 6-year-old daughter who is in school today and will be residing with her and the mother. $30,000 is a lot of bond for her to post. I would ask the court to set the bond more in the nature of $5,000 total.
5,000 total?
Yeah, $2,500 each count.
I understand that there may be some financial constraints in this case based on the information that you provided, Mr. Miller, but the allegations that have been brought against Ms. Pink in this case are obviously very serious, as we've already discussed this morning. Though I'm not making a finding of proof evident presumption great today, that doesn't lessen the seriousness of the charges that have been brought against her. Obviously, I don't have any background information regarding the incident. That's not before me to deal with today, but based on the probable cause affidavit, this is very serious.
Keeping in mind, Your Honor, this she has no prior conviction. She does have a 2013 battery charge that was dropped.
I understand.
allowed to say something that's not about the case?
Ms. Pink, let me just say a couple things to you, okay? For today's hearing, I'm only addressing bond and release conditions. We're not talking about the facts of the case at all.
Yeah,
All
I
right?
understand.
And Mr. Miller, your attorney's already given you that caution. So do you understand all of that?
Yes, ma'am.
All right. Go ahead if there's something else that you would like to tell me.
I understand, the paperwork that's against me, but I have a real strong will to change my life. Like, I'm supposed to start medical assistant school in 2 weeks, and I'm supposed to be doing better for myself. So I understand things happen in life, but I really have a strong will to turn over my life. I don't want to be back here in this courtroom ever again. So that's all I have to say.
All right. Thank you, Ms. Pink. The bond on count 1 will be set at $5,000. The bond on count 2 will be set at $10,000. If Ms. Pink does post her monetary bond, she'll be placed on pretrial supervision with a level 2 GPS monitor. And there will be an order of no victim contact.
Thank you, Your Honor.
All right, Ms. Pink, so that you understand my no contact order, that
Yes,
means no being in the same place at the same time as the alleged victim. Since you will be wearing a GPS monitor, that includes a 500-foot stay away from that individual. The no contact order also means no phone calls, no text message, no third-party contact, no social media contact. Do you understand that, ma'am?
towards the victim.
Correct.
Yes, I understand.
Okay, all
Your Honor, I
right.
would just ask for no firearms, weapons, ammunition.
All right, that's fine. Ms. Pink, there, yes, Mr. Miller.
I'm sorry to interrupt the
Go.
court. Just based on my reading of the probable cause affidavit, I'm requesting a photo order for this defendant.
All right, that's fine. I'll sign the photo order. Ms. Pink, there's also going to be an order that you possess no weapons, firearms, or ammunition. If you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
Yes, ma'am.
Okay, all right, thank you very much. Next will be Sabrina Rosenbaum.
Your Honor, it says that she was released at 4,200 hours this morning.
She has a VOP. How was she released? She has a VOP. Sheila, can you check that for me, please?
Yeah, I'm showing she's in custody as well.
Which facility is she supposed to be at?
North.
Is there a different arrest number? Okay, for my North Broward deputies, it looks like we have the wrong arrest number on here for her.
Yes, Your Honor.
So, let me just have, what's the correct arrest number? So it should be, at the end of it, it should be 605 is the correct one.
Okay,
Will
thank
you
you.
check that and then just come back and let me know? I'll move on to the next case while you check it.
Yes, ma'am.
Thank you. Thank you, Sheila. Next will be Bobby O'Hara.
I'm told that's a medical reset, Judge.
Okay. O'Hara's a reset. Brandon Della Porta.
Please approach the judge here. Come on up.
Thank
Sure.
you.
That was arrested 20 years ago.
Good morning, Mr. Della Porta.
Good morning.
You're before the court this morning on one charge of aggravated battery where offender knew or should have known the victim was pregnant. I find probable cause, and I'll hear from the parties.
One minute, did you have anything else? I don't care about that. Your Honor, based on the level of violence and the allegations, he has a prior, nothing related to this, nothing aggravating. I'd be requesting a $5,000 bond, no victim contact.
Judge, I just spoke to Ms. Delaporte. He does not think he can, his family's gonna be able to, quite afford that. I was gonna be asking for $3,500. As you heard, Mr. Delaporte is not a convicted felon. He's been here his whole entire life. He's 21 years old. My understanding is, his mother, who he lives with, is gonna help post his monetary bond. She works at IHOP, and he believes, Judge, if the court were inclined to set a bond around $3,500, that's something that his mother is going to be able to afford. Hence, that is my request.
The bond will be set at $4,000. There will be an order of no victim contact. Mr. De La Porta, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, sir?
Yes, ma'am.
Thank you. Tavares Calvin.
Mr. Calvin, come on up, please. He's approaching Judge Main.
Thank you. Good morning, Mr. Calvin.
Good morning, Judge.
Mr. Calvin, you're before the court this morning on 4 charges. Count 1 is for domestic battery by strangulation. Counts 2, 3, and 4 are separate counts for battery causing bodily harm, domestic violence. Mr. Linder, I do see we have multiple charges here for the battery charges. I understand based on the probable cause affidavit how the officer is listing them, but it looks like for count 4, I don't see that that's included. I think that appears to be made in error. I just want to confirm that I'm not missing any information.
Your Honor, I think what could be considered the third battery is the allegation of Mr. Calvin pinning the victim on the couch.
All right. I'm gonna make a probable cause finding. Obviously, I'm gonna take that into consideration when setting bond.
Sure.
But I'll find probable cause for the charges, and now I'll hear recommendations.
Yes, Judge. Mr. Calvin, in 2011, was convicted of grand theft and domestic violence battery against a different alleged victim. He violated probation in that case. I'm going to be requesting a $7,500 bond on the strangulation, $1,500 bonds on counts 2 and 3. Your Honor, whatever the court chooses to do on count 4, I took that allegation in consideration when recommending the bond on count 1, and no victim contact.
Mr. Romero?
Judge, Mr. Calvin's been here his whole entire life. He's 31 years old. As you heard, Judge, his last time, as far as contact with the criminal justice system is I believe, over 4 years ago, Judge. He is working. He works at a security place where he's been working about 2 years, where he's making about $13 an hour. He also goes to school. He goes to Southern Florida Bible College, where he attends Tuesdays and Thursdays. He will be living separate and apart from the alleged victim, specifically with his brother, who resides in Deerfield Beach. That's who I'm going to be contacting to help post his monetary bond. I believe his brother works in customer service. Their financial resources are quite limited. I was going to be asking for a $2,500 bond on count 1, a $1,000 bond on count 2, $1,000 bond on count 3, and on count 4, I was going to be requesting an ROR.
Bond on count 1 is gonna be set at $4,000. The bonds on count 2 and 3 will be set at $1,500. And count 4 will be an ROR. There will also be an order of no victim contact. Mr. Calvin, so that you understand the no contact order. That means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, sir?
Yes, Judge.
Thank you. All right, next will be Gene Diaz.
North Broward, Your Honor.
Yes.
Hold on a second. Your Honor, I just want to let you know on Sabrina Rosenbaum, she's in courtroom 4078 this morning.
Okay, so she's actually in court. She's probably in court on the VOP. All right, so we'll reset her. Okay. All right, good morning, Mr. Diaz.
Good morning, Your Honor.
Mr. Diaz, you're before the court this morning on 2 charges. Count 1 is for felony battery, domestic violence. 2 is a violation of probation, which has a no bond hold. I find probable cause, and I will hear from the parties at this time.
Your Honor, based on the level of violence, considering that this would be a second battery, and that he's on probation for the other battery, he also has a DUI property damage from 2017, strong arm robbery, 07, 2 years state prison as a habitual offender, shooting at or throwing a deadly missile, 01, VOP, 20 and a half months state prison. I'd be requesting a $15,000 bond considering the injuries she suffered. Also noting that the victim advised deputies that he has threatened to kill her in the past and that she does feel he is capable of committing such an act. So I'll also be requesting pretrial release of the GPS monitor should he be eligible for release at some point in time in this charge.
Thank
Judge,
you.
in light of violation of probation, we're going to reserve our argument for a future date.
Okay. All right. First up, let me just tell Mr. Diaz, you're gonna be seeing your division judge tomorrow morning on the probation violation issue, just so that you know. In light of the information, yes, Mr. Diaz, is there something that you're wanting to say?
Yes, ma'am.
Okay,
I've been
hold on.
probation.
Hold on 1 second. Before you say anything, I just want to give you the same caution that I give to everyone, which is I don't want you to say anything about the facts of your case, because the only thing I'm addressing today is bond and release conditions on this case. Do you understand that?
Yes, ma'am.
All right.
I just want to state I've been on probation. April would have been my last month for probation. I completed everything. I just needed to pay $1,250 in court costs. I completed all my mental health therapy. I did all my anger management. I was also on a DUI probation at the same time. I successfully completed all of that. I just want to put down the consideration for my bond so I could try to get reinstated and move forward with this.
Well, here's the thing,
Well,
Mr. Diaz. I'm sorry.
I'm sorry, I apologize. One more thing. I just had an ACL surgery last Thursday. So, I could get bonded out, but then to work to pay my bond, all that money, it's a lot for me because I got to get post-therapy. I got 3 herniated discs, so I can't work for about 3 weeks.
All right.
I'll bond out tomorrow, you know what I mean? If they were to reinstate me.
Right.
I was just hoping if they could lower my bond, I would have no contact with the victim. I don't want nothing to do with her anymore.
Okay. All right. Well, since you're going before your division judge tomorrow, then these issues can be addressed tomorrow. So in light of the information that I'm seeing, obviously the no bond hold stays as is. And I'm going to go ahead and, on count 1, I'm going to set the bond at $15,000. If you do post your monetary bond and you become eligible for release, you'll be placed on pretrial supervision with a level 2 GPS monitor. And there will be an order of no victim contact. So, Mr. Diaz, so that you understand the no contact order, it means no being in the same place at the same time as the alleged victim. Since you will have the GPS device, that will include a 500-foot stay away from this individual. No contact also means no phone calls, no text messages, no third-party contact, and no social media contact. Do you understand that?
Yes, ma'am.
Okay. All right, so you're going to see your division judge tomorrow, and you can address those issues further tomorrow morning. Mark Forkhand,
That looks like another medical
Still?
reset.
he's still in medical? Okay. Anthony Pickett,
He's approaching, Judge. He's here. Come on.
thank you. Good morning, Mr. Pickett.
Good morning, man.
Mr. Pickett, you're before the court this morning on a misdemeanor capias. This relates to a charge for petty theft. I find probable cause, and I'll hear from the parties.
Judge, after speaking with Mr. Pickett, he wishes to resolve this matter. My understanding is, in speaking with Mr. Pickett, I believe it stems out of Publix in which the merchandise was recovered. So at this time, we wanted to see if the state had a plea offer for him.
While Mr. Linder's looking at that, I just want to confirm, Sheila, on my finding sheet, okay, yeah, I was reflecting no bond. I just want to make sure that's not correct.
I know the ASA then documented the offer, so I guess I'll relay that. It's him. Adjudication, court cost, no return to Publix at 4849 Coconut Creek Parkway in Coconut Creek.
Judge, in speaking with Mr. Pickett, he wishes to accept the state's offer, and I did advise him as far as the consequences of having 2 prior convictions on a petty theft. The next time the state can file it as a felony, but it does realize that can happen, but he still wishes to go forward and accept the state's offer.
Okay, all right, thank you, Mr. Romero. Mr. Pickett, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Pickett, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
Oh, ma'am.
Are you under the influence of drugs or alcohol?
Oh, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Pickett, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served, and there will be a no return order to the Publix that was discussed. Do you understand that?
Yes, ma'am.
All right, good luck to you, sir. Shaim Moncrief.
He's here present, Judge.
Thank you. Good morning, Mr. Moncrief. Mr. Moncrief, you're before the court this morning on 2 misdemeanor capiases. These each relate to a charge for petty theft. I find probable cause, and I'll hear from the parties.
Judge, and speaking with Mr. Moncrief, he wishes to resolve these matters. So we wanted to see if the state had a plea offer for him today.
I do. It will be on both cases, adjudication, time served, court cost. On the 19-1753 MM20A case, no return to the Walmart at 3801 Turtle Creek Drive in Coconut Creek. On the 19-1506 MM38 case, it would be no return to the Walmart at 3001 North State Road 7 in Lauderdale Lakes.
Judge, he wishes to accept the state's offer.
All right. Did you advise him of the third strike?
I did, Judge, and I told him next time, even if he goes to Publix and steals something with the amount of a petty theft amount, it would be charged as a felony.
Thank you. All right, Mr. Moncrief, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And Mr. Moncrief, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
Ma'am.
Do you need any more time to speak with your attorney?
Definitely not.
Definitely not. Mr. Romero.
It's okay, Judge.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
That means if I haven't taken any drugs for this?
No, have you ever received any medical treatment for mental or emotional illness?
No.
Okay. Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right, and what plea do you wish to enter? Guilty or no contest?
No contest.
Okay, I accept your plea and find that it's freely and voluntarily given. Your sentence in both matters will be an adjudication, time served, and there will be no return orders to both of the Walmarts that we discussed. Do you understand that?
Yes, ma'am.
All right, good luck to you. Jeremy Turner.
Told that Mr. Turner bonded, Your Honor.
Okay. Thank you. Wilkervins Tamar.
He's here at main judge approaching. Come on up, sir.
Let me just check something real quick.
Good morning, Mr. Tamar.
No.
You're before the court this morning on a charge for loitering or prowling. I find probable cause, and I'll hear from the parties.
Judge, in speaking Mr. Tamar, he wishes to resolve this matter today.
Is there an offer from the state?
There will be, Judge, I just need to see one thing.
Go ahead.
Wasn't in the same area. I don't care about that. No, exploitation. Your Honor, the offer be adjudication, time served. No return to this listed location at 4431 Southwest 22nd Street in Fort Lauderdale.
Judge, he wishes to accept the state's offer.
All right, Mr. Tamar, will you please raise your right hand? Raise your right hand. I know it's a little difficult. Do the best you can. Okay. That's good enough. That's good enough. Do you swear or affirm to tell the truth?
Mm-hmm.
Yes or no?
Yeah. Say yeah.
She's asking you.
Yeah.
Do you swear to tell the truth?
I say yeah. I say,
All right, Mr. Tamar, you need to speak up. I have to hear a clear yes or no from you. Do you understand that?
yeah. Yes.
All right, not yeah. It's a yes, okay? All right. Do you understand everything we've discussed here today?
Yes. I'm released today. I'm being released today.
If you answer these questions, you will be.
Asking, that's what I'm hearing, right? I'm saying that's what I heard.
Yes, okay. All right, is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served, and there will be a no return order to the location this allegedly occurred at. Do you understand that?
Yes.
All right, thank you. Good luck. Javaris Johnson.
Mr. Johnson, Javaris, come on up, sir. He's approaching Judge Maine.
Thank
I don't
you.
think it'll be a problem.
Good morning, Mr. Johnson.
Good morning, Your Honor.
Mr. Johnson, you're before the court this morning on 3 charges. Count 1 is for second-degree petty theft. 2 and 3 are both misdemeanor capiouses, and those relate to charges for driving with a suspended driver's license and for petty theft. I find probable cause, and I'll hear from the parties.
Judge, Mr. Linder and I were just discussing whether or not the state can make an offer in this case. However, Mr. Johnson needs to be aware that if he does resolve these cases today, this is strikes 1 and 2 for him.
Correct.
And next time he gets arrested, it's going to be a felony.
Correct.
Okay, so first, as far as this would be a first DWS,
Okay.
So that's easy. I'll offer him a withhold on that. I'll offer him adjudication time served on counts 1 and 3.
Okay.
What was the plea offers on 1 and 3?
1 and 3 is an adjudication, time served. And is there a no return order with those?
Yes, on the new offense, it would be the Walmart at 5555 West Atlantic Boulevard in Margate. On the 191358 MM38 case, it would be the Marshalls at 4197 West Commercial Boulevard in Tamarack.
All right. So it's an adjudication, time served, no return on 1 and 3, and a withhold in court costs on 2.
Let me advise you, Judge.
Thank you.
Which isn't necessarily.
Judge, he wishes to accept the state's offer.
All right. Mr. Johnson, will you please raise your right hand? Do you swear or affirm to tell the truth?
I do.
Thank you. And now you can put your hand down. Do you understand everything we've discussed here today?
I do.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Do you need any more time to speak with your attorney?
I don't.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
I don't.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No, Your Honor.
And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
I understand.
And Mr. Johnson, what plea do you wish to enter, guilty or no contest?
No contest, Your Honor.
All right, I accept your plea and find that it's freely and voluntarily given. So once again, your sentence on charges 1 and 3 will be an adjudication, time served with the no return orders that we discussed. And on count 2, the sentence will be a withhold of adjudication plus court costs. Do you understand that, Mr. Johnson?
What does that mean? One moment, let me explain it to you.
Go ahead.
It's really.
I believe I answered his questions, Judge, if you wanted to inquire additionally.
Okay, that's right. Mr. Johnson, I just want to make sure that you understand what these sentences mean. Do you understand them?
I do, Your Honor.
Okay.
Yeah.
Okay. All right. All right, so that's going to be it for today. Good luck to you, Mr. Johnson. Okay, now Mr. Shate is with us in the courtroom, so if we have these individuals present, I will address our municipal ordinance cases. First up will be Maria Oliveras. I believe she's on page 1.
Judge, she just went to the restroom.
Okay, all right, I'll call her back. Michelle Vaughn on page 2.
Erica, 20 years as well. Page 2.
Thank
Vaughn.
you.
There's a trespass.
Good morning, Ms. Vaughn. Ms. Vaughn, you are before the court this morning on 3 misdemeanor capiases. Each of these relate to a separate charge for trespassing. I find probable cause. I have your 2 attorneys, Mr. Shate and Mr. Miller, are present with me in the courtroom since there is 2 of these are municipal ordinance violations and 1 is a regular misdemeanor. So, gentlemen, what are we doing with Ms. Vaughn's case?
The documented offer on count 2 from the state is a withholding court cost, no return to 6030 Hollywood Boulevard in Hollywood.
For the city cases, Judge, it's a time served offer as well.
Is that an adjudication on those?
It is, Judge,
Okay.
due to the number.
All right, so Ms. Vaughn, if you would like to resolve these three matters today on counts 1 and 3, which are the two municipal ordinance violations, the city's offers an adjudication, time served with no return. And
Okay.
on count 2, which is the state case, their offer is a withhold of adjudication plus court costs and a no return order. Do you understand those offers?
Yes, can I say something?
As long as it's not about the facts of the case.
No. So everything will be, time served today?
Yes.
Okay, yes.
Okay? All right. So, Ms. Vaughn, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Ms. Vaughn, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve these matters?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorneys?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And Ms. Vaughn, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. So once again, your sentence on counts 1 and 3 will be an adjudication, time served, no return. And on count 2 will be a withhold of adjudication, court costs, no return. Do you understand?
Oh, yes, ma'am.
All right, good luck to you, ma'am.
Thank you.
You're welcome. All right, also on page 2, Stephanie Jolly.
No problem.
Thank you.
Good morning, Your Honor.
Good morning, Ms. Jolly. You're before the court this morning on a municipal ordinance violation for trespassing. I find probable cause. Your attorney, Mr. Shate, is present in the courtroom with me. And Mr. Shate, what are you doing with Ms. Jolly's case?
Judge, this is a time served offer as well.
Okay, so Ms. Jolly, if you want to resolve your case today, the offer would be an adjudication, time served, and there would be a no return order to the location that this
Okay.
allegedly occurred at. Do you understand that?
Yes, ma'am.
All right, do you want to accept that offer today?
Yes, ma'am.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Ms. Jolly, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And Ms. Jolly, what plea do you wish to enter, guilty or no
No
contest?
contest.
All
No
right.
contest.
Okay, I accept your plea and find that it's freely and voluntarily given. As we discussed, your sentence will be an adjudication, time served, and there will be a no return order. Do you understand that?
Yes, ma'am.
All right, good luck to you, Ms. Jolly.
Real quick, Stephanie,
Stephanie, hold on.
Stephanie, come
Ms.
back.
Yeah.
You have another court case that's on March 2nd in front of Judge Levy, so make sure you come back on that, okay?
Oh, okay, good. Yeah, because my grandparents haven't gotten the mail yet. So, okay, so what is it, March 2nd?
March 2nd at the main courthouse, Judge Levy, Levy.
Does it say what time? 9 o'clock?
9 o'clock.
All right, thank
9
you.
o'clock. She'll show up at 9:45.
All right. Next will be Sonia Beasley on page 2. Okay. All right, so I guess I'll see you this afternoon.
Okay. You'll see Mr. Plant, judges.
All right. And
Lucky
Mr.
for you.
Shea, you don't want to come back this afternoon?
I would love to, Judge. I'll be in the doctor's office.
All right. All right, yes.
Come on, man. Olivia
Which
Olivares is here.
Okay. Which facility? Is it me? Okay. Thank you. All right. Good morning, Miss Oliveras.
Good morning, ma'am.
Miss Oliveras, you're before the court this morning on 2 charges. Count 1 is a felony violation of probation that has a no bond hold. And count 2 is a misdemeanor capias. That's a municipal ordinance violation for open container. I find probable cause. I do see, Ms. Oliveras, you are set to have a hearing before your division judge tomorrow morning on the VOP. So in light of that, I'm going to leave the bond in place on count 2, and so you'll be able to see your division judge tomorrow morning, all right?
Both charges going to be seen tomorrow?
You have a hearing for the VOP matter tomorrow morning, and on the misdemeanor case, the next day you'll go in front of Judge Lerner Wren, all right?
Okay, thank you, ma'am.
Okay, you're welcome. Good luck.
Thank you, Judge.
All right, next will be Dudley Brown on page 11.
Medical reset, Your Honor, North Broward.
All right, thank you, North Broward. Next will be Michael Willis on page 11.
North Broward.
Thank you. All right, good morning, Mr. Willis.
Good morning, Judge.
Mr. Willis, you're before the court this morning on a municipal ordinance violation for soliciting. I find probable cause. Your attorney, Mr. Shate, is present in the courtroom with me. And Mr. Shate, what are you doing with Mr. Willis's case?
I'm not sure if Mr. Willis has any, maybe Mr. Linder can tell us whether or not he has any violent crimes in his past. He might be eligible for community court.
Community court? Let's take a
Mr. Willis, without disclosing what they are, do you have any violent crimes in your past?
I had a robbery, no weapon. I don't know if that's a violent crime.
That's considered a violent crime.
Okay.
Well, that's the only thing
That's
in
the
my
only thing?
past.
All right.
All
Then-
right.
Then, Judge, you would not be eligible for community court, and the city of Fort Lauderdale would offer him a time-served offer.
Okay. All right, so Mr. Willis, if you want to resolve this matter today, the offer would be an adjudication, time served. Do you understand that?
I do, ma'am.
Okay, would you like to accept that offer?
I would.
All right,
Yes, ma'am.
will you please raise your right hand for me? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And Mr. Willis, do you understand everything we've discussed here today?
I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
I do not.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
I do.
And Mr. Willis, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. So once again, your sentence will be an adjudication, time served. Good luck to you, sir.
Okay. I had a question for
Yes.
the attorney there.
Yes.
Mr. Attorney, do you have any other court dates or anything listed out there? Because I'm homeless and I don't have a mailbox. And I just wanted to know if you had anything there in front of you that, court date
Yes,
or anything.
you have a felony case that's still pending, and you also have another charge that's still pending. Another
A
municipal.
felony case?
It's under
I don't have
Michael.
a felony case.
If I could have 1 second, Judge.
Go ahead. I just want to make sure that he knows what he needs to be here for.
I don't have a felony
What's your
case.
date of birth, Michael?
3/22/63.
3/22/1963. You have a petty theft as a habitual offender. It is going to court. You do not have a court date on that as of yet. It's a unfiled felony for too many petty thefts in your lifetime. But I can't tell you a court date because there is none.
Okay. So, Mr. Willis, that means that since there's not a court date set yet in that other case, that you need to be in contact with the clerk's office so that you know about any future court dates, all right?
Yes, ma'am.
Okay, all right, good
You
luck to
do have I'm sorry, Judge. You do have an arraignment tomorrow morning also in front of Judge Evans.
Is that on a separate case?
It is, Judge.
Okay, so you're gonna have a hearing in front of Judge Evans tomorrow, Mr. Willis.
At the main court?
Correct.
Okay.
Main court,
and,
5th floor.
Fifth floor, what time?
9 o'clock.
Okay, thank you.
You're
All right.
welcome.
Good luck, Mr. Willis.
Thank you.
All right, next will be Andre Crump on page 14.
No problem.
Thank you.
Here's our
He has a state case as well. All right.
Morning.
Good morning, Mr. Crump. You're before the court this morning on 3 misdemeanor capiases. Count 1 is a misdemeanor case related to possession of drug paraphernalia. 2 and 3 are municipal ordinance violations for trespassing and possession of drug paraphernalia. I find probable cause, and they are set at no bond. Let me just take a look at this. One moment. I'm going. Which judge is that?
Judge Brown.
So Judge Brown has set him at no bond on the 2 MO cases. So let me just ask either Mr. Shade or Mr. Linder, does he have a hearing date set right now?
For the second one, the number 2, he
Yes.
just missed his court date last week.
Yes.
It was returned because he never received it. So there is no future court date.
That's because the officers have, well, on the state case, he has, it just says at large. I'm not sure which address it was sent to, but I do see that the North Hack is the address given on the case with Judge Brown.
I'm not sure why she would give a no bond on that, Judge.
Well, that's unusual. That's why I'm questioning it, because obviously it's not often that you see no bond attached to a municipal ordinance case, but I do see that it's clearly marked in here. Sometimes I've seen them write 0 and what they really mean is ROR, but that's not the case here. I clearly see it's set at no bond. I'm sorry? Right, they just get stamped by the,
It would have been
It's
a
signed
time,
underneath.
it's a time served offer on these matters. I'm not sure.
I mean, if Judge Brown set it at no bond, then I'm not inclined to accept a plea, because
Okay.
I don't know if there is something else going on
Okay.
there that I'm just not aware of, and because it is an unusual circumstance.
Judge, what I can do is I can try, when I get back to my office, I can have him brought in to Judge Brown as quickly as possible.
Okay, all right. So then, are we gonna leave the state case where it is for the time being? I do see, just so that everyone knows, on this was medically reset from the weekend. There was a note that he's supposed to have a status hearing in front of one of the judges tomorrow morning.
Okay, perfect.
All right, so Mr. Crump, you're gonna be seeing your division judge tomorrow morning.
And what's division, Judge? What's that?
That's gonna be your regular judge who's handling this case, is the one that you're gonna see tomorrow, which is going to be, that's Judge Brown. It's Division MA is what it says on my paperwork here. So, Mr. Shate, you should be seeing him tomorrow.
Okay.
All right, so Mr. Crump, you're going to see Judge Brown tomorrow about your municipal ordinance cases, and your attorney, Mr. Shate, will be with you in the courtroom tomorrow morning. All right, good luck to
See
you,
you
sir.
tomorrow, Andre.
So what happened today? Nothing?
Nothing.
So nothing's gonna happen today. You're gonna go in front of the judge tomorrow morning. All right, good luck, sir. All right. All right, Mr. Shade, that's all that you've got, right?
Thank you, Judge.
Okay, and then I have one other case that we have somebody signed in. Let me just go to, let me go find it. All right. Daniel DeAndrea on page 23.
Morning, Your Honor.
Good morning, counsel.
Russ
How are you?
Formican appearing on behalf of Mr. DeAndrea. Mr. DeAndrea has
Oh,
hired
excuse me, I didn't realize he was
Kenny
out.
Padowitz to represent him.
Okay.
Mr. Padowitz called me. He's in Atlanta in court this morning, could
Okay.
not be here, so he asked me to come over.
Okay.
I don't have much knowledge of the case. I do know that Mr. DeAndrea doesn't have any significant prior history and has retained counsel, obviously, to address these charges. I've spoken to the state. I believe there's an issue that the jail may have the wrong subsection of the statute listed, which is why he was indicated as no bond initially.
It's been corrected, Your Honor. What happened was, and just for Mr. DeAndrea's edification, because I don't know if he already checked and saw that he was charged with robbery firearm.
Yes.
If you, I'm sure the court saw in the
It's a
warrant, it was
weapon,
charged
not a
robbery
firearm.
with a weapon.
Correct.
When he was booked, the jail put the wrong subsection.
All right.
They put 1A instead of 2A, which
That's fine.
makes it a robbery with weapon first-degree felony. I've spoken with counsel, with Mr. Cormican.
Yes.
I believe we have an agreement on a bond and release conditions if it's acceptable to the court.
All right, what's it gonna be?
There'd be a $10,000 bond, no victim contact, no return to this business.
All right, let me just say, for the record, I find probable cause for the charge of robbery with a weapon. I'm going to indicate that change on my finding sheet. And, per the agreement of the parties, bond will be set at $10,000. And there will be an order of no victim contact as well as a no return order. Mr. DeAndrea, so that you understand those orders, no return means you are not to return to the location that this allegedly occurred at. And the no victim contact order means that you are not to have any contact with the alleged victims in this case. That means no being in the same place at the same time. That means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, sir?
Yes, ma'am.
Okay. All right. Thank you very much.
Thank you, Judge.
All right, thank you, counsel. All right, next is going to be Tuan Ho. Thank you. Good morning, Mr. Ho.
Good morning.
Mr. Ho, you're before the court this morning on a traffic capias. This relates to a charge for failure to register a vehicle. I find probable cause, and I'll hear from the parties.
Judge, Mr. Ho wishes to resolve this matter. We want to see if the state had a plea offer for him.
Withholding court cost.
He wishes to accept the state's offer, Judge.
Okay, very good. Mr. Ho, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. Do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence in this case will be a withhold of adjudication plus court costs. Good luck to you. Next will be Devin Brown.
Been advised he bonded, Judge?
All right, thank you. Joshua Preto Perez.
I've been advised he bonded.
Okay. Aziz Gurbanov.
Come on up, sir. He's here at main, Judge.
All right. I'm being advised we have a corrected booking sheet.
Yes, ma'am. Count 3.
Yes.
If you can change the last of the case number, that is a felony probation.
Okay.
Okay, what's the?
Like CF 10A.
Okay, so the numbers are right. It just should be CF 10A. Thank you. Appreciate it. All right. Good morning, Mr. Gorbanov. You're before the court this morning on 3 charges. Count 1 is for disorderly conduct or breach of the peace. 2 is resisting an officer or obstructing without violence. 3 is a felony probation violation, which has a no bond hold. I do see you'll have a hearing before your division judge in that case tomorrow. I find probable cause, and I will hear from the parties.
Nothing from the state.
Nothing from the defense, Judge.
Okay, in light of that, the $100 bond will remain in place on count 2, and as I said, Mr. Gorbanoff will see his division judge on the VOP tomorrow morning. Thank you. Simon Hernandez Milano.
Bonded, Judge.
Thank you. Richard Polite.
Medical reset, Your Honor.
Okay. David Richard.
Judge, I've been advised he's in regular court.
Okay.
67A.
Rafael Marrero.
He's approaching, Judge. Come on up, sir.
Thank you. Good morning, Mr. Marrero. Mr. Marrero, you're before the court this morning on 5 charges. Count 1 is for second-degree petty theft. 2 is for possession of alprazolam. 3 is a felony probation violation with a no bond hold out of Seminole County. 4 is a felony out of county hold, that's from Seminole County. 5 is a misdemeanor out of county hold from Hillsborough. I find probable cause, and I will hear from the parties.
Judge, I did speak with Mr. Marrero. I did advise him as far as the Broward offense. He has a $1,000 bond. He advised me no one can pay that bond. And as you see here, he has a no bond hold, I believe, as the court said it, from Seminole County. I don't know if the court would be inclined to ROR count 2, so Seminole can come and pick him up.
He's also wanted out of Hillsborough County, Your Honor. Considering it's a felony charge locally, I'd ask that the court keep the $1,000 bond in place.
I do note the charges out of Seminole are driving related charges. So at this time, I will leave the $1,000 bond in place on count 2 so he can address the Broward charge, and then he'll be able to address the Seminole and Hillsborough issues at a later date. All right. Thank you. Jeffrey Klimas.
Mr. Klimas, come on up, please.
Good morning, Mr. Klimas. Mr. Klimas, you're before the court this morning on 5 charges. Count 1 is for possession of alprazolam. 2, possession of oxycodone. 3, driving while license suspended without knowledge. 4 is for having an expired temporary tag. 5 is driving a vehicle with unsafe or defective equipment. Counts 3, 4, and 5 are traffic citations that are not for magistrate. I find probable cause, and I'll hear from the parties on counts 1 and 2.
Judge, nothing to add from the defense.
All right. Anything further from the state?
No, Judge.
All right. In light of that, the standard bonds will remain in place on 1 and 2. Thank you very much. Ian Bowe.
Judge, he's approaching. He declined the services of public defender. My understanding is he's hired Mr. Michael Weinstein.
Has already hired him.
That's what he says. I think we contacted Mr. Miller.
I did not contact Mr. Weinstein. I can do so now, Judge, if you put that on a recall.
All right. I'll put Mr. Bowe on a brief recall. We'll see if we can get a hold of Mr. Weinstein, and if not, I'll proceed. So then next will be Scott Sullivan.
North Broward.
Thank you. Good morning, Mr. Sullivan.
Good morning.
Mr. Sullivan, you are before the court this morning on 1 charge of aggravated assault with a deadly weapon without intent to kill. I find probable cause, and I will hear from the parties at this time.
Your Honor, I'm being advised he has no history. It would appear he does not have ties to the community either. It looks like he resides in Connecticut. Based on the allegations, in lack of ties, I'd be requesting a $5,000 bond. No victim contact, no return.
Weapon without intent to kill.
All right, and Mr. Miller. Mr. Miller, you have any recommendation on Mr. Sullivan's case?
As I spoke with Mr. Sullivan earlier, he's visiting from Connecticut and
Yes.
plans to return there once he is released. He indicated that there was nothing that will prevent him from returning to address these charges should they be filed. He works for the Travelers Agency. He's been doing that for more than 20 years. He does have 2 children back in Connecticut. He's going to try to self-bond or have friends bond him out, and he plans to hire private counsel once he is released. And as far as he knows, he has no criminal record, and he is a registered voter back in Connecticut.
Do you have a monetary recommendation? Based on your conversation with him?
Judge, he seems like he's a pretty good risk, and
I have a friend that can bring money, right? A permanent resident that lives in Fort Lauderdale. Really good friend. He's going to come pick me up. He could, money wise, whatever.
he's not a danger to the South Florida community because he's going to be returning to Connecticut. I would ask the court to set a minimal bond at $1,500. Pretrial release is problematic, obviously, because he won't be in the state of Florida, but he understands that we do extradite from Connecticut. So, again, I think he's a good risk.
I think the risk always has to be tempered. If he was here in a straight third-degree possession or a theft, okay. He's accused of bringing a kitchen knife back to a restaurant and threatening people. And I don't know that just because he resides in another state, you could say, well, he's not a risk, because that would just give incentive. Well, if you're from another state, commit all the violence you want because you're going to be going back to where you came from.
I understand.
Judge, and also you have to take into consideration, he's 54 years old, and this is his first arrest. This is a one-off, clearly.
I understand.
Can I speak?
Mr. Sullivan, if you want to speak, then I will allow you to, but I want you to understand, I don't want you to say anything about the facts of your case. I'm only addressing bond and release conditions today. Do you understand that?
Okay, yes.
Okay. Is there something you want to say to me about bond?
No, that's okay.
Okay, all right. So in this case, bond will be set at $3,500. There will be an order of no victim contact and a no return order. Mr. Sullivan, so that you understand those orders, that means that you're not to return to the location this allegedly occurred at, and no victim contact, whether you know the individual or not, means no being in the same place at the same time. It also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that?
Yes.
All right, thank you very much.
Your Honor, in light of
Yes.
what I'm seeing here, I'm going to ask the court for a photo order. Mr. Sullivan, I'm going to advise you that if you bond out before my office is able to get to the jail to record your injuries, do something about recording them yourself. So have somebody take pictures of your face so that we can record your injuries that you received, okay?
Thank you.
And I'll sign that order.
Thank you, Your Honor.
Thank you. Okay, next will be Brendan Applegate. Thank you. Good morning, Mr. Applegate.
Good morning.
Mr. Applegate, you're before the court this morning on 6 charges. Count 1 is for second-degree petty theft, third or subsequent offense. 2, false identification given to law enforcement. 3 is for possession or use of drug paraphernalia. 4, resisting an officer or obstructing without violence. 5 and 6 are felony probation violations, each of which have no bond holds. I find probable cause. I do note that Mr. Applegate has a hearing before his division judge on the VOP matter tomorrow morning. So in light of that, do the parties wish to be heard on count 1?
No, Judge.
No, Judge.
All right, then I will leave that bond in place at this time. Thank you. Philip Welch.
Medical reset?
He's a medical reset?
Your Honor?
Yes.
The only thing I would ask the court to do, well, I'll address it when come back for the medical reset.
Okay. All right. Thank you. Next will be Lamar Smith.
Mr. Smith, come on up, please. He's approaching Judge Maine.
Thank you very much. Good morning, Mr. Smith.
Good morning, Your Honor.
Mr. Smith, you're before the court this morning on 2 charges. Count 1, driving while license suspended, third or subsequent offense. 2 is for failing to provide proof of insurance. I find probable cause, and I will hear from the parties.
Nothing to add from the defense, Judge.
Nothing from the state.
All right, in light of that, the standard bond will remain in place on count 1. Thank you. Next will be Andrew Katis.
He's here present, Judge Maine, approaching.
And Judge, I have PC arguments as to all counts.
All right. Good morning, Mr. Katis. You're before the court this morning on 6 charges. Count 1, possession with intent to sell, manufacture, or deliver cocaine. 2, possession with intent to sell, manufacture, deliver heroin. Counts 3 and 4 are each a separate count for attempted first-degree murder. Count 5, shooting a missile into a dwelling. Count 6, possession of weapon or ammunition by a convicted Florida felon. Mr. Miller, I will hear your arguments at this time.
Thank you, Judge. As to counts 1 and 2, that appears to stem from a search incident to his arrest. Law enforcement alleged that they found field test positive crack, cocaine, and heroin. And then they claimed that the narcotics were packaged in a manner for street-level narcotics. That's without any supporting facts. Normally, we see something, the number of packages, something to substantiate this. This is just conclusory, and I would argue that it's not enough to reach the level of intent to raise it from a third-degree felony to a second-degree felony. And so I'd argue there's only probable cause for possession for counts 1 and 2.
Okay, hold on. Let's address those first 2, and then we'll go to the next.
Your Honor, I'm fine with the court finding simple possession on 1 and 2.
All right, and then that would bring the standard bonds down to $1,000 each, right?
That is correct.
Okay. So on counts 1 and 2, I will find probable cause for possession of cocaine and possession of heroin, which brings our standard bonds down to $1,000.
Thank you, Your Honor. Now,
All right, and then we'll address the others.
So as to the remaining counts, Your Honor, I've read the affidavit in support of the arrest warrant in this case, and it would appear that there are 2 alleged victims / witnesses in this case. Neither of whom were able to see the face of the person who allegedly committed the acts that led to my client's arrest. It said that he was wearing a black shirt covering his face with 2 holes, that he was wearing, the person who committed these acts had dreadlocks, and I think they were, I'm sorry, I saw dread-like style brown hair to the middle of his back. Now, as you can see, the defendant in this case does not have dreadlocks, and I looked at the BSO pics in his case, and he's been arrested a number of times in the past. However, he's never worn dreadlocks. So then fast forward to an anonymous person contacting one of the victims saying that this person that we have in front of us today wore a brownish type wig, and that's it, and identified Mr. Katis to the alleged victim. Now, apparently, the alleged victim knew who this person was, or they knew who Mr. Katis was, and he was later identified, but they're not identifying the person at the scene of this incident, but rather identifying Mr. Katis as someone that they know. At least that's my reading from this probable the arrest affidavit. So they know who Drew is, but they don't know that they're not connecting him to the event. This anonymous person is giving information to the alleged victims, and they're making this assumption that he's the one who did it. He's identified, but not necessarily as the person who did this. And so I'm arguing there's no probable cause here to hold this man over on these charges.
All right. Mr. Linder, your response?
Well, first of all, I don't believe Mr. Miller is able to legally object to probable cause at first appearance. Judge Duffy has already found probable cause when she signed and issued the warrant. I think
Let me interrupt you for one
Yes.
moment, Mr. Linder. I apologize,
Sure.
but I am going to say, because I know where the conversation is going, I do understand Judge Duffy is the judge who signed the arrest warrant in this case, meaning that she has already made a probable cause finding. So I'm going to say from the outset, I will uphold her probable cause finding. However, based on the charges, I would assume that Mr. Linder is going to make a request for a finding, and
I'm not, Your Honor.
and you're not. All right. Well, I will take those arguments into consideration in setting bond.
One thing
Go
I
ahead,
would,
Mr. Linder.
and Your Honor, one thing I would note, Mr. Miller mentions about the hairstyle.
Yes.
What he didn't mention was his last arrest prior to this arrest
Yes.
was in 2012.
All right.
Certainly plenty of time to grow out his hair, to grow dreadlocks, and then to shave them off from when the incident occurred prior to his arrest on February 9th. Your Honor, you actually, and Your Honor, I would also note, and I think it would be reasonable for Judge Duffy to find an aggravating circumstance that there's clearly a motive for Mr. Cadiz to be involved in this shooting. Your Honor actually had the first appearance for one of the alleged victims last week, where he was alleged to have shot Mr. Cadiz's brother, his brother's son, and I think it was his, I don't know if it was Mr. Cadiz's son, but the third person in the vehicle was the victim's nephew. Additionally, Your Honor, I would ask the court to take into consideration that Mr. Cadiz, one moment. In 2006, he had an aggravated battery, great bodily harm. He was sentenced to 4 years in state prison as a habitual offender. 2011, possession of oxycodone with intent to sell or distribute, delivery of cannabis. On counts 3 and 4, I'm requesting a bond in the amount of $75,000 each. Considering the allegations are, which the court has found probable cause, is that Mr. Cadiz opened fire, shooting, not only shooting one victim, almost shooting another victim, and noting that their children were present in the home when he opened fire. On the missile into a dwelling, vehicle, building, or aircraft, I would be requesting a $25,000 bond, not asking any additional bond on count 6.
I'll defer to Mr. Romero regarding the amount of the bond, Judge.
Thank you.
Judge, I didn't hear as far as, and I apologize, as far as the state's recommendation, as far as the monetary bonds on 3, 4, and 5.
Okay, so we have, so far what we have is on 1 and 2, the standard bonds are $1,000 each. 3 and 4, the state has recommended $75,000. On count 5, the state has recommended $25,000, and then the standard bond on count 6 to remain the same at $5,000.
And Your Honor, I apologize, I also meant to request the GPS monitor,
Pre-trial with GPS.
please.
Judge, I understand that the allegations are very, very serious, and Mr. Cadiz will have his day in court. But in speaking with Mr. Cadiz, I do realize he has a prior history, but from what you heard from the state, he's been clean 8 years now, I believe, besides like traffic-related matters. But he's been here his whole life. He's 30 years old at this time. Unfortunately, he's not working. He's looking for employment. He lives in Pompano Beach with his mother, where he's been residing with his mom for the past 7 years. Right now, since he's not working, she is basically taking on the majority of the financial expenses associated with the rent. But because that her financial resources are limited, my understanding is she cleans houses for a living, and that's the person he's going to be relying on to help post his monetary bond. First, because of the his prior history and because of serious allegations, we don't have an objection as far as what the state has asked for as far as supervision with pretrial release level 2. But we are going to be asking regarding the monetary bond. There's no way him or his family can ever afford $175,000 on 3, 4, and 5. What I was gonna be asking the court to consider is $10,000 on 3, $10,000 on 4, $5,000 on 5. So with everything, if my math is correct, that would be about $32,000 with level 2 GPS is what the defense is requesting for at this time, Judge.
Mr. Romero, did you say that he is working or he is not working?
No, right now he's not working, he's looking for employment, and that's why his mom is like taking on the majority of the household expenses.
Bond on counts 3 and 4 will be set at $25,000 each. The bond on count 5 will be set at $10,000. The standard bonds will remain in place on the other 3 counts. If Mr. Cadis does post his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact in this case, and that will relate to both the alleged victim that was shot as well as his wife who was present at the time of the alleged incident. Mr. Cadis, so that you understand the no contact order, it means no being in the same place at the same time as the alleged victims. Since you will have a GPS monitor, that will include a 500-foot stay-away order from those individuals. No contact also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, sir?
Yes, ma'am.
Thank you. Juan Estevez.
Your Honor,
Yes.
I spoke to a private attorney who advised me he is representing Mr. Estevez.
Who is that?
I believe it was Larry Meltzer.
Meltzer?
Yes.
Mr. Linder's advising me that Mr. Meltzer is representing Mr. Estevez.
Okay.
Okay.
Assuming the court finds probable cause,
Yes.
we agreed to a $2,000 bond on count 2.
Okay. All right, Mr. Estevez, for the record, you're before the court this morning on 7 charges. Count 1 is for reckless driving, first offense. 2, fleeing with disregard to the safety or persons or property of others. 3, operating a motorcycle without a license. 4 is for speeding. 5 and 6 are disobeying or avoiding a red light. 7 is improper center lane use. Counts 4 through 7 are not for magistrate. I do find probable cause. And Mr. Linder, the state attorney present in the courtroom with me, has advised me that he spoke with your private counsel, Mr. Meltzer, and they have agreed to a $2,000 bond on count 2, which I will approve at this time.
And just so Mr. Estevez understands,
Yes.
Mr. Meltzer he's in Palm Beach. He couldn't make it here this morning. That's
All
why
right.
he reached out to me.
Okay, Mr. Estevez, did you hear that?
Yes.
Okay. All right, good luck to you, sir.
Thank you.
Thank you, Mr. Linder.
Yes, Judge.
Morris Ashman.
Mr. Ashman, come on up, please.
Good morning, Mr. Ashman.
Good morning.
You're before the court this morning on 2 charges. Count 1, criminal mischief over $1,000. 2 is for throwing a missile into a dwelling. I find probable cause for these charges, and I'll hear from the parties at this time.
One moment, Judge.
All right. Mr. Romero, if you want to go first, you can go ahead.
It's okay. It's okay.
Yes, Judge. And speaking of Mr. Ashman, Judge, he's been living here his whole entire life. He's 22 years old. He's looking forward to coming to court. He advised me he's not going to miss and he's not a flight risk. Having said that, Judge, my understanding, where he was living, I believe that's where the incident took place. I did advise him that the court's going to order no return and no contact. That's not going to be a problem for him. He's going to be abiding by that order. He's going to live with the mother of his child. He has one child, Judge, and what he does, he basically buys and sells cars for a living, fixes them up. So every month it's like a different amount, depending if he finds a right car and if he's able to even sell it or fix it that month. So his wages fluctuate. Having said that, Judge, he has an informal agreement where he pays child support. He makes sure that his child is well taken care of, and his child's mother is the only person that's going to help post his monetary bond. My understanding is he has very limited contact with the criminal justice system, from what he had told me. The last time he got arrested or contact, I believe, was at a date for some traffic offense or traffic-related matter. I'm going to be asking the standard bond remain the same on count 1, but what I was going to be asking on count 2, I believe the allegations, from what I've been advised, are serious. So I'm going to be asking for a $4,000 bond on count 2 on Mr. Ashman's behalf, Judge.
Thank you.
I'm fine. Hector, you said 4?
4,000.
Yes.
I'm fine with that. No victim contact, Judge.
Okay. All right. So then the standard bond will remain on count 1. Count 2, bond will be set at $4,000. There will be an order of no victim contact as well as a no return order, as we discussed. Mr. Ashman, so that you understand those orders, that means that you're not to return to the residence that this allegedly occurred at. And for the no contact order, that means no being in the same place at the same time. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that, sir? I need
Yes,
to hear
ma'am.
it. Thank you. Mr. Miller, were you able to get in touch with Mr. Weinstein? Okay. I can keep going. I just wanted to check in.
What did Andy Williams do that person?
Okay. Okay, all right. Let me go back to Mr. Bowe's case. All right.
Mr. Bose, what page was he on, Judge?
Ian Bowe, B-O-W-E. He's the one that declined the public defender and said Mr. Weinstein's representing him.
Oh,
Page
Mr.
17.
Bowe.
17?
Yeah, there he is. Ian, come on up.
Okay. All right, Mr. Bowe, I've just been advised that Mr. Miller reached out to Mr. Weinstein. He has confirmed that he's not yet representing you in this case. Do you understand that?
Yes, ma'am.
Okay. So, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Well, I don't understand. He's not representing me, meaning.
He said that he has represented you previously, but he is not yet representing you for this case that we're dealing with this morning.
So, is there any way I could get in contact with him to be able to?
Well, here's what I want to advise you of, okay? If you would like to have the public defender represent you for this hearing and then hire him later, then you can do that. If you,
Okay,
if you want to represent yourself for this morning's hearing and hire him later, you can do that. But,
Can I get a public defender for now and then I could hire him later?
yes, all right, so I'm gonna give you a few minutes to talk to them, and then I'll bring you back up, all right?
Okay, thank you.
Okay. All right, so next will be Andy Williams. And I believe there's a correction needed on this. On Mr. Williams on count 1. Yes. When I look at the probable cause affidavit in the booking sheet, in the finding sheet, it's different. Mr. Williams, I'm not, what page is he?
He is on page 21, Judge.
Thank you.
That's what we were seeing. Mr. Williams was concerned when I read him
Yeah,
his charges.
it's incorrect. I'll make the correction. All right, so for Mr. Williams, he is before the court this morning on 2 charges. Count 1 is for lewd or lascivious conduct by a person 18 years of age or older. My finding sheet in the booking sheet indicates a person less than 18, but that's incorrect when I look at the probable cause affidavit. Yes.
Your Honor, if
Go ahead.
there should be no PC for count 1.
Okay, so you're not requesting the correction?
There's nothing really to correct, Your Honor. In order for those statutes to apply, the victim has to be less than 16. And clearly,
So
the
it's
alleged victim in
incorrect.
this case is 16.
All right, then on count 1, there will be no probable cause. And count 2 is a charge for lewd or lascivious behavior involving cohabitation.
Yes, Your Honor, I'm going to be requesting a $250 bond on count 2. He does have a history. He was released from state prison. 2019? April 2019.
That's fine too.
Okay.
Okay, all right, so on count 1, since there's no PC, count 1 will be an ROR, count 2 will be a $250 bond. All right.
Judge, can I get a property order so he can self-bond?
Yes, you can get a property order, and yes, Sheila.
Thank you.
What was that?
You put a 250 on count 2,
Correct.
but on count 1,
It's ROR.
okay, but on the finding, did you change it to reflect the,
I'm not, I didn't even correct the finding, I just put no probable cause, because Mr. Linders advised me even if I changed it to the way we were talking about, it still wouldn't apply to him. Correct. So I'm putting no probable cause for count 1. I'm not making any further adjustment to it. So count 1 will be an ROR, count 2 will be put at $250. All right? Thank you. Chase Reed.
He's here present, Judge.
Thank
He
you.
declined the service as public defender. He's proceeding pro se.
All right, thank you. Good morning, Mr. Reed.
Good morning, Honor.
Mr. Reed, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes, ma'am.
And are you declining the services of the public defender at this time?
Yes, ma'am.
All right, so Mr. Reed, for the record, you're before the court this morning on 3 charges. Count 1, possession of THC. Count 2, possession or use of drug paraphernalia. Count 3 is operating a vehicle with unsafe or improper equipment. That count is not for magistrate. I find probable cause. I see the standard bond on count 1 is set at $1,000. Mr. Linder, are you seeking anything further?
No, Judge.
All right, so I'm going to leave the standard bond at $1,000, and there's no bond attached to count 2, Mr. Reed, all right?
Yes, ma'am. Thank you.
Good luck. Shamari Powell, bonded? All right. Mark Anthony Braxton. Thank you.
So, Your Honor, I had a chance to look this case over.
Yes.
It's a filed case,
Right.
and count 1 alleges fraud that was occurred over a period that extended to March 1st of 2019.
Okay.
He went on probation on February 28th, 2019.
Right.
And he had been in custody from February 26th to the 28th. Although technically it would appear that there is probable cause to hold him for violating that probation.
Right.
I would argue there's not probable cause because my experience is that the state just picks these time frames kind of arbitrarily.
You're talking about for the violation of probation?
Yes, ma'am. So while there is no warrant.
Judge Usan signed a warrant.
Let me just
Very
take a
well.
look.
I will hold the argument. He's going to see his judge tomorrow anyway.
Yes. Okay. All right. So let me just go, just for the record, Mr. Braxton, you're before the court this morning on 6 charges. Counts 1 and 2 are each felony violations of probation, which have no bond holds and do have a hearing before your division judge tomorrow morning. Count 3 is for obtaining property over $20,000 by fraud. That's organized fraud in the 2nd degree. Counts 4, 5, and 6 are each grand theft between $5,000 and $10,000. I find probable cause.
I thought this was just a probation violation.
No, sir, there was a warrant already out for you on these other charges as well. Okay, it's not just, there's 2 violations of probation, but there are also other charges that are pending. So, let me just ask the parties, in light of the no bond holds, do the parties wish to be heard on the other charges?
Judge will defer our argument for another day.
All right,
No, Your Honor, the only thing I would ask
Yes.
is that the court issue a no contact order, and that would be for Marin by Arium, Lay Point at Jacaranda, and Bella Plantation.
Those are 3 apartment complexes?
Yes, Your Honor, I believe so.
All right, so the no contact order would apply to the representatives for those complexes?
Yes, Judge.
Okay,
Just
all
no
right.
turn.
So I will leave the bonds in place as they've been set, and Mr. Braxton, the no victim contact order I'm going to put in place applies to the 3 apartment complexes that Mr. Linder just referenced?
I don't understand what's going on, sir, ma'am. I was told that this was a probation violation.
Okay, well,
I understand.
Mr. Braxton, there are a number of new, I understand that when law enforcement was in touch with you, it was due to the 2 pending violations of probation. There are also other charges that have been brought against you, so I'm going to let you discuss that with your attorney following today's hearing, because I don't want to have any discussion about the facts of the case on the record with you, all right?
Okay, so I'm being held on probation violation, or?
So you are
or
being
the
held
charges?
you're being held on the 2 violations of probation, as well as the fraud and theft charges that have been brought against you. All right, you're going to see your division judge tomorrow morning on the probation violation, and I'm gonna have you discuss the other charges, the new charges that are brought against you with your attorney after today's hearing. All right?
Okay.
Okay. Good luck to you, sir.
And Judge, whenever the court's ready, I'm ready to proceed on Mr. Ian Bowe.
Okay, let's go ahead to Mr. Bowe's case now. All right, Mr. Bowe. For the record, you're before the court this morning on 1 charge of aggravated assault with a deadly weapon without intent to kill. I find probable cause, and I will hear from the parties.
One moment, Judge.
Okay.
Your Honor, the state would be requesting a $15,000 bond, no victim contact, pretrial release of the GPS monitor. I'm concerned about the level of violence that he allegedly threatened the victim with a knife, that he held it to her body. What is also causing me additional concern, Your Honor, is the fact that he just completed a diversion program for domestic violence battery. Less than a month before this incident. He completed it January 13th of this year.
Is that involving the same alleged victim?
No, a different victim.
All right. Mr. Romero?
Judge, he did advise me about that, and ultimately the state did drop the charges. So my understanding is being Mr. Bowe, he's 32 and he's been living here for almost 13 years. He's going to be having no contact with the alleged victim. He's going to be residing with his uncle, who resides in Miami. Now, my understanding is his uncle is not employed, he receives disability. That's the only person that can help post his monetary bond, and Mr. Bo is working. He works at Sonny's Car Wash, where he's been there for about 6 months. So, Judge, considering he has very strong ties to the community, he has a clean record. I'm going to be requesting the court consider a $3,000 bond on Mr. Bo's behalf.
State, does he have any priors besides the one that involved the diversion program?
One moment, Judge. Your Honor, I see no priors, but a couple things I would like the court to be aware of. As far as the allegations from the probable cause affidavit of the previous case, according to the victim, while he did not make any type of threats, he was in possession of a handgun in his other hand when he struck her multiple times on the side of her head with a closed fist, obviously using the other hand. The victim in that case and Mr. Bo have a child in common, and while he did not witness the incident, he was inside the residence at the time of the altercation. I sent it to you. I think we had it. Here it is.
All right, the bond in this case will be set at $3,500, and if Mr. Bo does post his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will be an order of no victim contact. Mr. Bo, so that you understand that order, that means you are not to have any contact with the alleged victim. Since you will be wearing the GPS monitor, that includes a 500-foot stay away from this individual. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that?
Yes, ma'am.
Thank you. David Johnson.
Yes, ma'am.
Thank you. Good morning, Mr. Johnson.
Good morning, Your Honor.
Mr. Johnson, you're before the court this morning on 2 charges. Count 1 is for second-degree petty theft, third or subsequent offense. Count 2 is for trespassing in an unoccupied structure or conveyance. I find probable cause. Your attorney, Mr. Miller, is present in the courtroom with me, Mr. Johnson, and at this time, I'll hear recommendations from the parties as to bond.
I'm not asking for
Judge,
anything.
3-year resident of South Florida. He is currently homeless. He plans to live in a shelter once he is released. He has no one to bond him out, and unless the court is interested in releasing him to the services of pretrial, Broward Sheriff's Office pretrial services, he's going to sit in custody until this case is resolved.
Mr. Linder, does he have priors?
He does, Your Honor. He just resolved a felony theft early October of last year. In that case, he was before Judge Porth. He failed to appear on one occasion. He was placed on pretrial initially in the case. He had to be taken into custody because he violated pretrial. He, I don't think he ever reported to pretrial.
Okay. All right, I'm going to leave the standard bond in place at this time. There will also be a no return order. Mr. Johnson, that no return order means that you are not to return to the Walmart that this allegedly occurred at. Do you understand that, sir?
Yes, ma'am.
All right, thank you very much.
Okay. You know when my next court hearing is?
Does he have an arraignment hearing set yet? Let's check. Hold on one second.
Sort of make a finding. Did he come through all weekend? All right, I'll take care of it. Okay, so
Judge, this case is unfiled.
Okay, so then no date has been set yet.
And that appears to be all he has at the moment.
Okay, all right, so Mr. Johnson, the court date hasn't been set yet, but you'll get notified when it is, all right? Okay, next will be Ryan Ware.
Your Honor, I'm being advised he's, it's a medical reset.
Okay,
I would ask the court, if Your Honor would, make a probable cause determination one way or the other. I've been advised he's been reset from last week and throughout the weekend.
yes.
Without objection, Your Honor.
All right, then at this time, I will make a probable cause finding with respect to these charges, and we'll reset him for bond. Next will be Isaiah Cherenfont.
Showing he's at the main.
Medical reset, Judge?
Okay, and I believe that brings us to the end of our morning docket, so I'll see everyone back here this afternoon. Thank you.
Thank you, Judge. Mr. Favar.